Welcome, everybody. We're going to get started in just a minute or so. Nice to see you all. Good evening. I'm David Myers, a member of the board of Jewish Currents, and I'm pleased to welcome you to this first event in our Futures Forum series. For 75 years, Jewish Currents has been home to progressive and radical Jewish thought. Over the past 3 years, the magazine has been reinvigorated by an exceptional cadre of young writers, thinkers, and activists, and it's gained a reputation for trenchant, thought provoking, and indeed provocative political analysis and cultural criticism. Jewish Currents probes, pushes, upends, reorders, and demands of us a response. But this work is not for the sake of provocation alone, nor is the aim to offer rigorous analysis of the status quo and its many sources of inequity alone. Rather, animating Jewish Currents, at least as I understand it, is the impulse to imagine and agitate for a different and better future. And this brings us to the Futures Forum. In a series of conversations over the next few months, we will explore the present and future of key issues and trends in society today. On each occasion, we will bring together leading scholars and thinkers to enrich and complicate our understanding. Our aim is decidedly not conformity or singularity of voice. Rather, we aim to conjure up the cacophony of the Beis Midrash, the Beit HaMidrash, the study hall in which Talmudic disputation proceeds, in order to clarify what the stakes are and how we can do better. Our next Futures Forum will be in a mere 2 weeks on October 19th, when we will discuss the future of American Jewry through the lens of Haredi, or ultra-Orthodox Judaism. Today, we'll inaugurate our series with a conversation about the quite astonishing career of the idea of religious liberties in the United States. A great deal of public attention has fallen on this concept now, in the age of COVID, when we encounter those who say that the right to religious liberty trumps, and here the pun is intended, the right of the government to guarantee the public's health. How did this come about? What transformation of the relationship between religion and state has occurred in what would seem to be a post-secular age? And where might an ever-expanding notion of religious liberties lead? We have really an extraordinary group of thinkers to discuss the matter, not all of whom hold to the same views. Divergence and disagreement are encouraged, and I would even say likely. To preside over the conversation, we're fortunate to have Daia Lithwick, legal analyst extraordinaire, author, and host of a great podcast that you should all check out, Amicus. Thank you for hosting this first Futures Forum, Daia, and now I hand things over to you.
So thank you so much to David and to all of you who are tuning in. And I really do want to take a moment to say what an honor it is to moderate this evening's discussion, this inaugural panel in the Futures Forum. And I want to just amplify what David just said. It's really hard to imagine a moment in which we could possibly be more suited and I think obligated to discuss the future of religious liberties. And as you're going to hear tonight, this question inflects on virtually every hot button issue that is currently dividing the country, from COVID lockdown orders to LGBTQ rights to reproductive and contraceptive freedom. And so we are going to attempt to do the impossible in 54 minutes, which is cover the past, the present, the future of religious liberty, the cases on the Supreme Court docket, and what this shift that David has described means for both democracy and religion. So we're going to try to have a moderated conversation for about 35 minutes, and then we're going to take your questions. I'm going to invite you to pop your questions into the Q&A and not the chat. And we will get to as many of them as we can in the last 10, 15 minutes. And I just want to add to what David said, if I had to magic up a dream panel to explore these issues, it would look a lot like the folks you're going to hear from tonight. Each of them I could introduce for 25 minutes and we could be done. So I'm going to give very compressed biographies, but in your materials from tonight, please take a moment to appreciate the scholarship of these folks. Catherine Frankie is the James L. Dorr Professor of Law and Director of the Center for Gender and Sexuality Law at Columbia. She's among the nation's leading scholars writing on law, sexuality, race, religion, drawing from feminist, queer, and critical race theory. She is also the founder and faculty director of the Law, Rights, and Religion Project, which is a think tank based at Columbia Law School. Her first book, Wedlocked: The Perils of Marriage Equality, considers the cost of winning marriage rights for same-sex couples. She was awarded a Guggenheim Fellowship in 2011 to support that. Her second book is Repair: Redeeming the Promise of Slavery's Abolition, and it makes the case for racial reparations in the US. Our second panelist is Avi/Michael Helfand. He's Professor of Law and Vice Dean for Faculty and Research at Pepperdine Caruso School of Law. He's also co-director of Pepperdine Law's Newt Institute on Law, Religion, and Ethics. He serves as a visiting professor and Oscar M. Rubenhausen Distinguished Fellow at Yale Law School and a senior research fellow at the Shalom Hartman Institute of North America, where I'm also a research fellow. Avi received his JD from Yale, his PhD in political science from Yale, and his academic articles and his legal articles have appeared in journals ranging from the Yale Law Journal and the New York University Law Review to the Wall Street Journal, the LA Times, Tablet, and Forward. Next, we have Micah Schwartzman. He is the Hardy Cross Dillard Professor of Law and Director of the Karsh Center for Law and Democracy at the UVA School of Law. He focuses on law and religion, jurisprudence, political philosophy, and constitutional law. Micah received his BA from UVA, his doctorate in politics from the University of Oxford, where he was a Rhodes Scholar. Micah's work has appeared in places including the Harvard Law Review, University of Chicago Law Review, and his opinion pieces have appeared everywhere from the New York Times, the Washington Post, to the New Republic. He co-edited The Rise of Corporate Religious Liberty, Oxford University Press, and is co-authoring a forthcoming casebook on constitutional law and religion. Last but certainly not least, Nomi Stoltzenberg is a legal scholar whose research spans a range of interdisciplinary interests, including law and religion, law and liberalism, law and feminism, law and psychoanalysis. She occupies the Nathan and Lily Chappell Chair at the USC Gould School of Law. She's a co-director of USC's Center for Law, History, and Culture. And her new upcoming book, American Shtetl: The Making of Kiryas Yoel, a Hasidic village in upstate New York, co-authored with David Myers, will be published by Princeton University Press this December. I want to welcome this phenomenal panel. And I want to invite all of you to both answer my questions and fight my questions, as one learns to do on the first day of law school. And let's try to cover a lot of ground in a very tiny amount of time. Micah, this is going to require at least a brief history of the religion clauses, the Religious Freedom Restoration Act, where the kind of arc of religious liberty started, what the intention was, where we have come. So I'm going to ask you, standing on one foot, to set the table, if you will, by giving us kind of a speed read of the relevant legal provisions, constitutional and statutory, that we're going to talk about today, and how the courts have thought about them.
Thanks, Dahlia, and thanks to Jewish Currents. You said set the table, and I already had in mind, this is sort of like Who Knows 13 in One Breath, the history of free exercise in 60 seconds, right? So here goes. I think you can start at least thinking about the First Amendment and the Supreme Court's application of the free exercise of religion. That is our understanding of religious liberty. You could begin in 1879 with a case called Reynolds against the United States involving Mormon polygamy, a federal ban on polygamy, where the Supreme Court upholds that ban and rejects a First Amendment challenge to it. From 1879 to roughly 1963, the Supreme Court doesn't really grant any religious exemptions. So no exemptions between the late 1800s and 1963. In 1963, we get a case called Sherbert versus Ferner, which sets a different framework during the Warren Court, in which the court signals some willingness to consider religious accommodations under the First Amendment. That era persists through the next 27 years up to 1990. And during that era, the Supreme Court seems open, but it really grants very few religious accommodations. There are only really 5 cases during that entire period in which the court grants a religious exemption. And 3 of those cases are basically repeats of each other. In 1990, this so-called golden age of religious liberty seems to come to an end. The court, with Justice Scalia writing for a narrow majority, adopts a very stringent understanding of the free exercise clause in a case called Employment Division versus Smith. That's the peyote case, very famous in this area, where the court says that as long as the law is neutral and generally applicable, the Supreme Court is not going to upset it by granting a religious exemption or accommodation from it. And people are very unhappy with this decision in Employment Division versus Smith. It leads to lots of legislation, both at the federal level and at the state level. At the federal level, the most important piece of legislation is the Religious Freedom Restoration Act. But at least with respect to the constitutional doctrine of free exercise under the First Amendment, that decision in the peyote case, Employment Division versus Smith from 1990 through I think really the last couple of years, 2018, but for about 25 more years, the Supreme Court grants no more religious exemptions. There was only one case in 1993, but you have to go right up until Masterpiece Cake Shop to see another case involving the court striking down the application of a law on free exercise grounds. So we get 25 more years. So here I'm just going to borrow a line from Chip Lupu and Bob Tuttle in a recent paper on the free exercise clause, a paper I think is worth checking out. But basically they say over a 200-year span in American history, you really only have 20 to 30 years in which the court has an active docket looking at religious exemptions and granting any of them. But all of that has changed in the last few years. And I think at this point, it's fair to say we have a Supreme Court that is more solicitous of religious accommodations, more willing to grant them than at any point in United States history. This Supreme Court loves religious exemptions and has seen a wide range of cases since the mid-2000s. We have cases involving exemptions from the Affordable Care Act's contraception mandate, exceptions from federal anti-discrimination law. We have the Colorado bakery case, Masterpiece Cake Shop, involving a free exercise claim against a public accommodation law that prohibited businesses from discriminating on grounds of sexual orientation and gender identity. And now we have COVID public health and safety cases challenging capacity limits and other types of restrictions on religious organizations. And right around the corner from all this, I think we're about to see just a huge amount of litigation involving vaccines and religious exemptions to vaccines. So the doctrine has changed, I think, in quite substantial and important ways with respect to free exercise. There's a second clause, of course, in the First Amendment, and that is the Establishment Clause. And we've seen quite dramatic changes, I think, in the Establishment Clause over the last several years as well. Basically, the Supreme Court has taken a wrecking ball to the separation of church and state and demolished, especially with respect to funding of religious organizations, demolished its prior jurisprudence, which required some kind of separation. The court does not seem interested in policing the boundaries of government speech that supports religious messages. I think the Roberts Court hasn't seen a winning Establishment Clause claim before it. You have to go back to the early 2000s to find such a claim. And I don't expect the Establishment Clause to play a significant role in the court's jurisprudence. So basically, if you're taking a really kind of 30,000 foot perspective on all this, you've got now a very expansive conception of religious liberty under the Free Exercise Clause, and almost no Establishment Clause to speak of in terms of recent cases. And that's where we are in a nutshell.
That was impressive. Avi, I want to spike it to you. I was going to ask you to sort of flesh out the school funding cases, but maybe Micah's touched on it. And I wonder if maybe you want to react to Micah's framing in terms of either, when things start to shift or how they start to shift, or if the two trends that he's essentially laid out are those trend lines are trend lines that you would characterize the same way.
I think I pretty much agree with Mike on the trend lines. You certainly have seen an expansion of the Free Exercise Clause and a pretty significant constriction on the Establishment Clause. I think, when you look at Micah's description, one of the great puzzles is, why hasn't the Supreme Court gone all the way? This is the question that still remains. Micah mentioned, the 1990 case of Employment Division versus Smith, where the court kind of constrained the Free Exercise Clause, said as long as law is neutral and applies across the board, under those circumstances, there's no constitutional right. Laws can do as long as they're neutral and apply across the board. And I think there's been an expectation, at least in some corners of the legal community, that what this will lead to eventually, the current court, is an overturning of Employment Division versus Smith. And one of the things that we've seen over the past couple of years is the court just seems not wanting to go all the way. Most recently, I know we'll talk about it more, Fulton v. City of Philadelphia. I think some folks thought, hey, here's an opportunity where the Supreme Court's going to expand explicitly in very clear ways what the new test is for religious exemptions. And it didn't happen. The court seems to want to play under the current framework. It's almost as if we've seen an expansion of the Free Exercise Clause in a variety of ways, but a reluctance to change the overall framework. So that, in that way, maybe that's a slight, addendum to Micah's comments. It's a push, but not a willingness to kind of rework the whole game. And that's interesting. I suspect we'll talk about that in the coming minutes. I don't know if you want me to chat a little bit about funding, Dahlia. I can,
Let's circle back to funding, and just because I want to bring in Catherine. Micah has flicked at this, but I want to develop it a little more. Really, the big shift starts to happen around LGBTQ rights, and the big shift seems to happen around Hobby Lobby and reproductive freedom, and I would add contraceptive freedom to the list. So I think I want you to answer two questions. One, flesh out why suddenly this engenders this massive sort of pushback for religious exemptions. And I don't know, Catherine, if you have a universal sort of high-level theory of why these are the issues that really begin to create this demand for religious exemptions. I don't know if I'm asking you way too meta a question for the third question in a panel, but what is it about these civil liberties that start to engender the pushback that we get?
Thanks, Dahlia, and thanks to Jewish Currents for inviting me and for holding this panel. It's just so great to be in conversation with such smart people. I'm going to push back a little bit on the trend line that the two previous speakers offered, not to disagree with the Supreme Court's jurisprudence, but to say there was a lot of religious liberty action happening and exemptions happening outside of the Supreme Court. So as a regular matter, Title VII requires accommodations of the religious practices of employees, and that's a regular thing that employees whose religious practices might conflict with, say, Saturday work, if that's their Sabbath. That is an uncontroversial kind of thing that routinely happens in workplaces. So too in prisons, where there were faith-based reasons to ask for exemptions from what would be neutral, obviously neutral practices in the prisons, or food, those sorts of things. But the place that I think we've omitted in our discussion is abortion and reproductive rights. And there is a long history in this country of turning to religion as the form of backlash against emerging, and for some uncomfortable, new social norms. And so Brown versus Board, the backlash there was initially faith-based in the creation of private schools that would remain segregated. And there was a lot of back and forth in the courts about whether that was legitimate. And then when Roe versus Wade is decided in 1973, immediately the backlash takes the form of religious objectors, whether it is about funding, whether it's about people, healthcare providers, whether it's about insurance companies, across the board, the right to abortion, the right to make a decision about whether to terminate a pregnancy, and then access to that procedure has been effectively hollowed out since almost immediately after Roe versus Wade was decided. So that was the proving ground for what came later. So the day after Obergefell, the Supreme Court same-sex marriage decision comes down, this advocates on the right have a panel. And one of the things they say is that we're going to give Obergefell the Roe treatment. And they have, right? They have treated not just same-sex marriage rights, but other equality rights for transgender people and other members of the LGBT community. The same treatment, which is to say, you can have that right, but it doesn't apply to me. It's to create an exception to what should otherwise be a constitutional right that is portable across public and private contexts. Now, this is not just hot button issues that have received this, what one say, outsized attention, and I would call a kind of deregulatory impulse to say, actually, the law can't regulate me because I have a faith-based objection to falling within the law. We've seen not just about Hobby Lobby's challenge to the contraceptive mandate in the Affordable Care Act, but faith-based objections to the unionization of workers in faith-based colleges, faith-based objections by employers for minimum wage laws, bans on child labor, workers' compensation laws, whistleblower protection laws, sexual harassment laws. Similarly, there have been faith-based objections to requirements to protect kids in schools from race-based bullying, access to the regular divorce laws, or the being held to regular divorce laws, and child abuse laws have been met with religious objections, and so many more. So I worry generally about the deregulatory effect of the widening of faith-based objections and then demands for exemptions. But I think what we're also seeing is the tiering of rights that the Supreme Court has inaugurated in this last term, that certain rights are first-tier constitutional rights, and that would be religious liberty. And I think this term we're going to see gun rights as well. And others which are not explicitly enumerated in the Constitution are second-tier rights. They're rights that we will respect so long as they don't impose some cost on first-tier rights. And that's where racial equality, LGBT equality, reproductive rights, women's equality, et cetera, resides in these kind of second-tier rights. And then your last and big question about why now, there are these incredibly well-funded right-wing evangelical nonprofits that have flooded the courts. The Alliance Defending Freedom, Liberty Council, Beckett, and others, Thomas More Society, there are many of them. And they've had an agenda, and they've been incredibly effective in pushing that agenda in the courts and in legislatures to create specific carve-outs from laws they object to, largely having to do with sexuality in the family, but not only. The Koch brothers paid for a good part of the Hobby Lobby case, and they have a deregulatory goal more than a sort of evangelical goal. So I think it's partly about funding, that these groups have been well funded and they're smart lawyers and they're doing a good job and they're winning.
So that actually is a really nice segue to the question I want to bring Nomi in on, which is, and every single, I think, panelist has mentioned the COVID cases, but the COVID cases really hyper fuels the TikTok that you've heard described. And suddenly this isn't objecting to, civil rights protections. This is, I object to lockdown orders that state public health entities have put into place. And I wonder, Nomi, if you wouldn't mind, it's a little bit of a Torah standing on one foot again, but if you would walk us just through, because I think the arc of the COVID cases profoundly changes and accelerates. And I think we'll talk about it because I think it matters that this happens on the so-called shadow docket in some instances. So do you mind just helping pull the threads of what everyone else has talked about and locating the COVID cases in that theme? And I just want to remind folks to put questions in the Q&A. Okay, go ahead, Noam.
Sure. Thank you, Dahlia. Thanks, everyone. It's a pleasure to be here. So, I think one aspect of what you're asking for, the Torah on one foot, is just an overview of what happened in the courts, and in particular in the Supreme Court, in response to religious liberty challenges to COVID regulations, and then how to situate that in the sort of broader developments that have just been described. So the quick overview, first of all, shout out to the Law, Rights, Religion Project at Columbia, established by Catherine, run by Liz Platt, and the report they put out doing just this, providing just an excellent overview of all of the religious liberty challenges to COVID regulation. So I really recommend that people take a look at that. The basic story is a story of before Amy Coney Barrett and after Amy Coney Barrett. And of course, that has everything to do with what my colleagues have been talking about the rise of a movement that has a radically different vision, a radically more expansive vision of the scope of the right to free exercise of religion than has been recognized, at least squarely, by the Supreme Court in the past. So between April of 2020, which is very shortly after we wake up to the pandemic and restrictions are put in place, and April of 2021, at which point pandemic's not over, but many people are vaccinated, and that's just one of several reasons why the most restrictive limitations on religious gatherings and on all religious gatherings, they've been largely phased out. But up until that time, we saw dozens of lawsuits being brought in federal courts in different states across the country, primarily by churches, challenging the application of these restrictions to houses of worship, to religious activities. And you mentioned the first wave of these restrictions are stay-at-home orders, and those were certainly immediately objected to because those really required churches and other faith groups, houses of worship, to just close. And there were a few challenges to those, but that was succeeded pretty quickly within a matter of months by a loosening of restrictions. Churches were allowed to open, but other restrictions were put in place, numerical restrictions, capacity restrictions, maybe masking restrictions. So of these many cases, the lower courts kind of go different ways. But very quickly, you mentioned the shadow docket, and we might want to take a time out, but I'm not going to do it quite yet to explain what that is. Many of those cases very, very rapidly make their way up to the Supreme Court. And the way that happens, this is what the term shadow docket refers to, is before a trial has even begun, before the cases have even been fully briefed, the churches make applications for emergency orders to block the governors of the state in which they happen to be from enforcing the restrictions against them pending the outcome of the litigation, right? So it's these emergency orders which have a fast track to the Supreme Court, because someone's got to decide whether the restriction is going to be enforced pending an adjudication of its constitutionality. So ultimately, there's 4 cases, really 5, but 2 of them are consolidated. The Roman Catholic Diocese of Brooklyn versus Cuomo, and Agudat Israel, the organization that represents the interests of Haredi Jews versus Cuomo. Those are consolidated into one. 2 of these appeals for emergency injunctions reached the Supreme Court. Actually, many of them reached the Supreme Court. Nearly a dozen reached the Supreme Court. But in 4 cases, the Supreme Court does something quite unusual, which it not only makes a decision as to whether or not to grant the injunction, but it actually issues opinions. That's unusual to do. And it issues opinions that, at least in the last 2 cases, actually really radically change the framework that the Supreme Court uses to assess free exercise claims. So that's the before Amy Coney Barrett and after story. The 2 cases that the Supreme Court addresses before her appointment, right? This is before Justice Ginsburg has died. In those 2 cases, the Supreme Court denies the application for these appeals by a thin majority, but a majority that includes not only the then 4 liberal members of the court, but also Chief Justice Roberts, who even goes to the length of writing a concurring opinion to explain his disagreement with the conservatives who write a blistering dissent. Within less than a month after Amy Coney Barrett is appointed to the Supreme Court, she's appointed at the end of October. At the end of November, the Supreme Court addresses the challenges to Cuomo's restrictions that were brought by the Roman Catholic Diocese and Agudat Israel. And it issues opinion. Now the erstwhile dissenters are in the majority, right? Joined by Amy Coney Barrett. And a number of months later, in July, in the case of Tandon v. Newsom, so this is a case similarly involving challenges to similar numerical restrictions that were implemented by the governor of California. Those 2 cases not only represent the broader pattern that appears as soon as Justice Barrett is appointed, which is almost every single grant for an emergency application for an emergency injunction is now being granted. But those cases, and here I'll end this summary, it's the reasoning of those cases that is so very startling and really introduces a quite radical change to the court's framework of analysis for testing the validity of free exercise claims. In a nutshell, what the Supreme Court, the majority, the conservative majority, states is what some people have referred to, not the Supreme Court itself, as the most favored nation principle. In the words of the Supreme Court, and this is an interpretation of the Free Exercise Clause that a number of conservative justices and lower court judges and advocates have been advocating for, but this is the first time that the Supreme Court squarely says the following: government regulations are not neutral and generally applicable, and they therefore trigger strict scrutiny under the Free Exercise Clause whenever they treat any comparable secular activity more favorably, subjected to less restrictions than religious exercise. And then the court goes on to emphasize, it says it's no answer that the state treats some comparable secular businesses or activities as restrictively, so long as any comparable secular activity is not subjected to the challenged restrictions. Then according to this new doctrines, the restrictions also have to be lifted from the comparable religious activity unless the state can meet a very, very heavy burden of justification. The last thing I'll say is not only is that in and of itself a really, really radically new doctrine with quite radical implications, but I think perhaps even more disturbingly is the way the doctrine is being implemented. Remember, the court itself says it's only if a comparable secular activity is not subject to restrictions, then there's a right to religious exemptions from the restrictions. But that means in theory that if grocery shopping, the risks of grocery shopping are much lower, they're not comparable to the risks of sitting together and singing together for a prolonged period of time, then this principle does not require. But what's really notable, and I would say disturbing about the opinions, is the court simply rejects the conclusions of the state that are made in reliance on the conclusions of public health authorities and scientists. After all, it is not a question of law, it is a question of fact, whether the risks are comparable. And you could call that the abandonment of the traditional principle of judicial deference to expert opinion, or you could just call it, I would, denialism. The court simply asserts that these favored activities are comparable, as if their risks are comparable, and it rejects the conclusions of scientific experts to the contrary. So that's a quite dramatic change, not only in doctrine, but in the way that doctrine is being implemented, that bespeaks that solicitude for religious exercise, and maybe the exercise of certain religious groups that Micah was speaking about in the beginning.
Thanks, Nomi. That's incredibly clarifying. I want to give both Micah and Avi, who worked on these cases in different contexts, a chance to respond and maybe to either push back on or agree with Nomi's central contentions. One, that the big thing that changes is RBG goes and Amy Coney Barrett comes, and that two, the court kind of secretly changes doctrine itself and implements this unspoken most favored nation status, and they don't exactly do it in a way that is clear why they did it or how. So Micah, do you want to take a whack, and then Avi can respond?
Sure, I basically agree. There's no question that Barrett's joining the court was a turning point. We've got before and after cases, as Nomi said. She's clearly right about that. I don't think anyone disagrees about that. The court shifts right. The chief loses his position as the median voter on the court, and the outcomes favor religious organizations more heavily than they did prior to. I think all that's clear. How big a change is the court's decision in tandem to adopt a single secular exception or most favored nation status interpretation of the Free Exercise Clause? I think it's a really big deal. So I agree with Nomi about this. I think there's almost nothing left of employment division versus Smith. At least there's nothing left when the court doesn't want there to be anything left. And that's the real question. I mean, when does the court want to rely on Smith and when does it not want to? Well, it hasn't in the last several cases that it's seen. It's got plenty of outs doctrinally. Masterpiece Cake Shop The court says that state actors were hostile to religion. They expressed animus. In Fulton, the city of Philadelphia case involving Catholic social services, the court, with the chief writing on some pretty hard-pressed state law technicalities, finds that there's a discretionary exemption and uses that to get out from underneath the idea under Smith that the law is neutral and generally applicable. I mean, pretty much if the court doesn't want to apply the old framework under Smith, it doesn't have to anymore, but it's left Smith in place, which leaves this question, like, why? Why didn't they overrule Smith? That's the question that Avi mentioned. And look, one answer might just be they want to be able to use Smith's rule in some cases down the line. They want to be able to say some laws are neutral and generally applicable. What might be a kind of law that a conservative court might want to call neutral and generally applicable? I mean, I don't think it's hard to find one. I mean, one might be, let's say, SB 8, right? An abortion restriction. I mean, if Smith is still on the books, then you say, look, the law is neutral and generally applicable, and then you don't have to grant religious exemptions from it. I think we're going to see religious exemption claims in the abortion context, and I think they're going to get turned away. And the question is, how are they going to get turned away? And I think one answer is, to the extent that Smith is still on the books, courts are, especially the lower courts, are going to be inclined to say the laws are neutral and generally applicable. So I think the rule in Smith now is highly manipulable. It wasn't, I think, for a long time, but after Barrett's joining the bench, I think it is. And now the court has lots of tools available to it to grant religious exemptions that it favors. And when it doesn't favor them, it has tools to find that the laws are insulated against that kind of scrutiny. That's maybe cynical, maybe too realist, too critical. You can consider it a kind of prediction. I think that's what it's going to look like.
Okay, Avi, so Micah's dropped the legal realism hammer, the total cynicism mic drop. Do you concur? Do you disagree? Tell us how you're processing what was, I think, regardless of how we characterize why it happened, the shift of the last year.
First of all, I definitely agree with both Micah and Nomi. I mean, as Micah said, I don't even understand. It would be hard to disagree. Obviously, the addition of Justice Barrett to the court certainly changed the composition of the court, and I think changed outcomes. So I think that's got to be right. And outcomes would have been different had she not been on the court. I think that also is obviously correct. I'm less enthusiastic about the characterization of these injunctions as secret. I think they're less than. I don't think of them quite as secret. I guess I'm less shocked by the idea that kind of executive orders from governors got emergency treatment by the court. Emergencies beget emergency judgments. It doesn't seem as shocking to me. So I'm not as blown away by it. I think Nomi's right to say that there's a lot of writing over here, but if we're trying to figure out like how many clicks on the dial surprised should we be, I would characterize myself as slightly less surprised that, in a pandemic that, the world hasn't seen maybe ever, maybe in over 100 years, and that had lots of restrictions on various forms of liberty in order to promote public health, the Supreme Court responded on emergency basis. That just seems less surprising to me. In terms of the content, I mean, maybe it's worth putting a little bit of meat on the bones in terms of kind of the logic of some of, why, I think I agree with both Micah and Nomi that free exercise doctrine, religious liberty doctrine now is a lot less predictable. It wasn't particularly predictable, by the way, back in like before Smith in the 1980s. I think it was like a complete crapshoot when you showed up to the court as to kind of what kind of rule you were going to get. But there's a certain kind of, a new kind, I would say, of indeterminacy to the law. And that has to do with questions of comparability. This is kind of the puzzle that courts are always dealing with. It's hard to figure out kind of how to do this. And the basic premise in free exercise doctrine, we talked a little bit about employment division v. Smith, and the basic idea is if the law is neutral and applies across the board, the law is fine. You don't have a religious right to say, I get an exception to the law as long as it's neutral and applies across the board. The kinds of exceptions, and Mike, I think, referenced the Supreme Court's decision in 1993, kind of exceptions you get is when, it starts to look like other folks are getting exceptions from the laws, or you have some sort of kind of local level or certain kinds of administrative discretion where some people seem to be getting a get out of jail free pass, kind of like when the teacher gives a homework assignment and some people are being told, no, it's okay, you don't have to do the homework. You're like, well, why do I have to do the homework? In those cases, you start to see, this argument that the idea that some people get exceptions and not others, what that means is you like me less. And when you say that to religion, you like religion less than other things in some contexts, that triggers a new kind of religious liberty claim, the idea that you're treating religion as less than. And that presents its own kind of quasi-discrimination problem. That's kind of the logic of it all. So here's the problem. The problem is, well, how do I know if I'm being discriminated against? Is my claim like that person's claim? You gave them a get out of jail free card and you didn't give me, but maybe that's because there are good reasons to treat the two of us differently. And that presents a wide range of puzzles. I think the courts was bad at this both before Barrett and after Barrett. I mean, just to give an example, one of the claims pre-Barrett was in Nevada, you had a church show up and say, we'd like to have 50 people, more than 50 people come into our chapel, and the court said, no, you can't have that. That's crazy. And they're like, did you look at what you let the casino down the road do? And they put some pictures in their briefs, like there are tons of people in there for hours and hours, way longer than any service in the church. And you're saying those folks are fine in there. That's not a public health issue. But in the church, we're afraid of the spread of COVID. Now, we all understand Nevada casinos are going to get a little bit better treatment. I mean, that's what makes the place run. So you can imagine in those circumstances, churches started to say, we think this doctrine about who are you treating in what way, we're not getting a fair shake on this. You can see why, that in those cases, you might see why maybe there's some sort of claim to this kind of quasi-discrimination. The court pre-Barrett, just didn't respond to that one. Justice Roberts decided not to write a concurrence in that case. Nobody explained from the majority why they declined to issue an injunction. Post-Barrett, you also have all these puzzles. Hard to know, kind of the Goodeth Israel case, the Archdiocese of Brooklyn. In that case as well, you had some of these strange puzzles, like how do you know who's like what to figure out if religion's being discriminated against? And if I were trying to put some logic as to what was going on in that case, I think ultimately the court was driven by the following. You had some of these sanctuaries, one of which got a lot of airtime, that seats 1,400, and Governor Cuomo said you can't have more than 10 people in there. And then on the flip side, down the block, certain essential businesses, and that category seemed maybe a little broader than you might like in a pandemic. There you could have 100% capacity. And part of, I think, the court's reasoning was, how does that make sense? Like, we get it. People aren't as businesses as much and as long, but I mean, 100% capacity in there, and you can't get more than 10 people in the 1,400 person chapel. Like, something seems off here. Now, what does this judgment look like? It's really hard to figure out if we say courts can engage in this judgment. It feels like a tough public health matrix, and maybe the response should be, we get it, this seems weird, but maybe the court shouldn't be doing it. And then maybe on the other hand, you might say, something is really, really off here. And so maybe we want Cuomo to have to go back and try to change a little bit, give a little more leeway or a little more explanation. Maybe I'll wrap up by saying the following. I think part of the problem here, obviously, is the pandemic itself. I think part of the problem, of course, is the changing facts of the pandemic and how hard it was for state and local government to keep up. I don't think local government did a particularly great job of being transparent, and sometimes I would say even honest in some of these cases. I can just say personally from some of the dealings I had out here in LA County, phone calls with particular government officials, I was sometimes shocked when I would request from government officials, all I would like for you to do is the rule you're telling me on the phone, just put it in writing in the guidance and we will comply. And an unwillingness to be transparent and clear about the guidelines that would restrict lots of institutions, and particularly religious institutions. I think when you hide the ball like that, the public, starts to wonder if this is about public health or if something else is going on. I worry about that. I certainly worry about instances and cases like that. And while the doctrine is shifting in one way, it probably opens up also an important conversation about the authority that we give local officials. And I would say the kinds of discretion that the Free Exercise Clause in the Supreme Court tried to worry about back in 1993.
Catherine, I want to give you an opportunity to respond to a couple of things that Avi just said, one of which is this analysis by analogy, that becomes the bread and butter of the COVID cases. Is church more like a bike shop or less like a bike shop? And maybe also this thread he's pulling on, which is most favored nation status is a response to least favored nation status. And I think, and I'm trying to be mindful of time and there are questions, but I think the thing we haven't quite fleshed out is Fulton. And that is the foster care case from this term, which is another case that either stood for something or nothing, depending on how you read it. So that's a little bit of a massive brief, but you can answer all three of those or any one or do whatever you'd like. Thanks.
Well, what I will do is be brief because I want to leave room for questions because there are a bunch of folks I know queued up. So just very quickly, the Fulton case involved the city of Philadelphia that had like many large cities, a human rights law that prohibited sexual orientation and marital status, race, sex, et cetera, discrimination, including those who were entering into contracts with the city. So say you had a construction company, you couldn't discriminate on those bases if you contracted with the city to build a road or something. So Catholic Social Services enters into a contract with the city of Philadelphia to provide foster care placement services. The city's overwhelmed, so many kids in foster care, they need help from private agencies, and there's a long tradition of Catholic agencies doing this. But Catholic Social Services doesn't want to comply with the non-discrimination provision around sexual orientation and says, because of our religious beliefs, we want to place children with married heterosexual couples. They won't place them with married gay couples, same-sex couples, or unmarried people for that matter. So there's also marital status discrimination going on by the lights of the city's human rights law. And so just very quickly, Catholic Social Services sues to keep their contract. When the city says, look, if you're not going to comply with the human rights law, then we can't contract with you. And they say what you're doing violates our religious liberty rights. And in fact, you're discriminating against us as a religious organization. Why? And this is the argument the Supreme Court actually adopted, which seemed unthinkable not that long ago, is that the city of Philadelphia is discriminating against a religious objector if it has only in theory the possibility for a commissioner to grant an exemption from the human rights law. He has never, or they have never in the history of the human rights law granted an exemption, but it is written into the law that they have the power to do so. And so the Supreme Court says, look, see, a comparable secular exception, as Nomi laid out. If you've got that, even though never exercised, then you must grant a religious exception or exemption from the law. Otherwise, you're discriminating against faith-based contractors. Now, the only thing I have lots to say about this, but the only thing I'll say right now about it is that what we are seeing is the Supreme Court finding and now fleshing out a new source of equality rights in the First Amendment's free exercise clause that is so much more protective of equality for faith-based entities or people's religious beliefs than we get under the Equal Protection Clause, where normally we see equality claims arise for race, sex, a range of other things. And that I think is troubling, is that this Supreme Court finds it impossible to see race discrimination in voting rights, criminal justice, mass incarceration, you name it, can't find it. But it's easy for them to find discrimination against a faith-based contractor, even though they've sort of fabricated this comparable secular exception. That I think is just important to hold at the same time, is that we've got an evolving notion of being much more protective of religion-based discrimination than every other form of discrimination. And that's not written into the Constitution, nor do I think it was in the intent of any, if you like this sort of thing, the framers, the old dudes who wrote it.
I want to get to some of the questions in the Q&A, and one of them really lands on something that I've been struck by. I know Avi's talked about it too, which is what does this mean for the Jews? That, this is a fascinating moment where for many years, the Jewish amicus brief in industrial complex was pretty quiet. And more we're seeing a split with briefs on both sides of all these issues. And Fulton was just, that the Philadelphia case that Catherine just talked about, it was just one of many cases where we had strongly argued Jewish values being urged on both sides. And so I sort of fatuously said at the beginning that, what does this mean for the Jews that we're comfortable on both sides of these issues? Does anyone want to try to answer what this tells us about both Jewish values and how Jewish values are evolving in America right at this moment? Does anyone have a thought? Nomi.
Sure. Well, you point out that there are Jewish advocacy groups lined up on both sides of all of these cases. And I think that reveals something really important. It reveals that the relevant dividing lines, the religious dividing lines, are no longer denominational. We're living in a trans-denominational world. What matters is a dividing line that cuts across many, if not every, religious denomination, certainly including Judaism or Jewish culture more generally, certainly including every brand of Christianity, including Islam, including Hinduism. And that is a dividing line between two different philosophies about the place of religion in society. Or you might call them two different political theologies. It's a dividing line between, you ask about Jews of faith, Jews of faith who are liberals and secular Jews who are liberal on the one hand. That is to say, they subscribe to a liberal view of the place of religion in society, which insists upon the removal of religion from the public sphere, the separation of religion from state, the protection of religion in the public sphere, the protection of religious liberties, and an insistence upon the value of equality, that everyone has an equal right to liberty, and that necessarily entails limits on the right to exercise your liberty so that you don't exercise your liberty in a way that interferes with the rights of others. Against that is a conservative, anti-liberal, anti-secularist, anti-egalitarian political theology that repudiates all of those liberal principles. And we see this division within every faith tradition. So Jews, many Orthodox and Haredi Jews, have really signed on to the project and the movement spearheaded by conservative Christians to dismantle the separation of church and state, as Micah talked about, to repudiate a liberal interpretation of freedom of religion as an equal right that necessarily entails the duty not to exercise your right in ways that causes harm or undermines other important rights. That's the fight that's going on.
Avi, do you want to respond? I feel as though you want to say something, and I also want to just say maybe we'll stay for 3 more minutes or 4 more minutes, just because I feel like there's ground to cover. Avi, do you want to talk?
I'll do my best to talk quickly. A couple years back, Micah and Rich Schrager wrote this great piece called Jews Not Pagans, trying to articulate kind of the way in which Jews fit like a middle ground in some of these culture war issues. And at the time, the editor of the volume that paper came out in was also kind of curious about the place of Jews in all this. And so I got this request, well, like, what's the history of Jewish advocacy when it comes to the First Amendment? I didn't really know a ton myself. So I set upon this project to read every amicus brief ever filed by a Jewish institution since the beginning of, time with respect to religious liberty. Because I was curious kind of like where we were and where we're headed. And I'll try to summarize just some basic findings, and that I think a lot of which track, some of which may be a little different than some of Nomi's comments just now. I think when it comes to the Establishment Clause, Jewish institutions, at least initially, were very, very strong Establishment Clause proponents, certainly up until the 1960s. And then you kind of started seeing a little bit of a difference where Orthodox Judaism, while reluctant to get involved in questions of religious symbols or the like, when it came to questions of funding, neutral funding, funding provided to analogous institutions across the board, differed from the Jewish establishment. But so by and large, you saw kind of in symbolic cases, Jewish institutions not supporting religious symbols on government property, et cetera. But when it came to funding, you saw a bit of a split. And by and large, that trend has, I would say, largely continued. I would say on the fringe, you've seen a little bit of a rightward turn among some Orthodox groups, ever so slightly starting in recent years to come out in favor of certain kinds of religious symbols on government property. The American Legion case from a couple of years ago is probably a good example, but let me just leave it at that. On the religious liberty side, it's been a little bit different. Religious liberty side, you used to see Jewish institutions across the board favor religious exemptions all the way back. And that started to change also for reasons that I think Catherine touched upon, some of the increasing questions around women's rights, reproductive rights, et cetera. But initially you saw a pretty unanimous voice of the American Jewish community in favor of religious exemptions. Even when it came to things like for-profit entities, you go back to briefs from the 60s. This was just taken as a given within Jewish communities. You've seen more of a split recently in a couple of interesting ways. One is Jewish institutions increasingly, progressive Jewish institutions, increasingly reluctant to see things as religious exercise. I'll give you an example. In the recent Fulton case that Catherine talked a bit about, you had Jewish groups filing a brief where they expressed, at least as best I can read it, the view that social services, provision of religiously motivated social services ought not be viewed as religious exercise. That's a weird view, I would say, a strange view for progressive Jewish institutions, because social services has long been a part of the Jewish vision for what it means to be a Jew in this world and to, try to provide for others in the way God intended. So, that's been a little bit of a change in terms of the constriction of what counts as religious exercise. I'd say on the right side of the ledger, I start to see in ways that, Nomi was describing, far more willingness to press on certain kinds of religious exemption claims. One good example might be the Baker case. There's a brief filed in that case from an Orthodox Jewish institution where, they press the argument that, wouldn't there be a religious violation if somebody Jewish were required to bake this kind of cake? But they say it in a way where if you read it carefully, it's pretty clear, Jewish law doesn't really prohibit baking a cake for a same-sex wedding. And here what you see is kind of, I would say, on the right side of the aisle, expanding the claim of, what it is that, what exactly constitutes or is religious exercise. So if you see on the left a minimizing of what's religious exercise, I would say on the right, you see an expansion of what constitutes religious exercise. And, maybe in both those ways, you see both, the polarization we see in society generally and concerns that maybe, just maybe, some of this polarization is taking away from the unique Jewish voice that I would say existed, more clearly in the 60s, 70s, 80s, and even 90s. I think that's a point of concern. I think Jews filed more amicus briefs up until the 90s than any other faith communities in religious liberty claims before the court. And their voice was unique. And you do begin to worry a little bit that, it's starting to flatten a little bit with other kinds of political identities. And that seems to me, to answer your question directly, Dahlia, a bad thing for the Jews.
Micah, Catherine, I want to give you one last opportunity to respond and maybe to ask a question that I've seen a few iterations of it in the Q&A, which is, what about religious liberty claims in the abortion context on the progressive side? What about religious liberty claims in the immigration context on the progressive side? Is there a way in which this should be pressed to kind of effectuate progressive values? Catherine, do you want to take it?
Well, I think, as you know, Dahlia, and others, I think, who are on this panel know, I've been doing that work for quite some time, working with groups in the Southwest, putting out food and water for people, migrants coming across the desert and in terrible, very deadly circumstances, environmental activists, anti-nuke activists, things like that. But we've been doing amicus briefs in those cases to urge the court to take the religious liberty claims a little differently than they're being argued by the religious right, so that there is actually a test that you have to pass. Because right now the courts have been so solicitous of the right wing's religious liberty claims in the COVID cases, I think that Nomi described are a great example, that they almost don't have to assert anything, and then it's on the government to justify what they're doing. And I think the test should be stringent. I think we should look at what the third party harms are. Is there some cost to respecting religious liberty in this context? And how do we balance thoughtfully these competing claims to rights, to safety, to citizenship? And the courts are not really doing that in the right-wing cases, and I think they should. And so we're asking them to do it in the left-wing cases to kind of repair the damage that we've seen in some of these cases like Hobby Lobby and Masterpiece Cake Shop and now Fulton. With respect to the abortion cases, we're already writing that complaint. We're ready to raise those religious liberty claims, but I have to say, with a great amount of pushback and ambivalence by some reproductive rights advocates who are, worried that we'll recharge the arguments made on the right. And I think of equal importance, they feel, look, we don't need more religion in healthcare, reproductive healthcare. What we need is more science and more medicine. And so why are we bringing in more religion? And it's a hard question. I'm not sure there's a right answer to it, and I feel deeply uncomfortable and mixed about it.
I think we could at least stipulate that we could have gone another 2 hours. That we really only scratched the surface of what I truly believe to be an existential, collision of different rights and values. I want to thank the amazing panelists who gave us their great brains today. I want to thank all of you for sticking around for 7 extra minutes. And I really urge everyone to keep being involved with this Future Forum series that I think at every level is trying to surface the kinds of very, very, very thorny and I think urgent conversations we had today. So thank you all. Thanks to Jewish Curtains for hosting us, and we'll see you on